In September 1985, a Marine Corps drill instructor named Jerry Ensminger lost his 9-year-old daughter to leukemia. Her name was Janey. She was ill for nearly 2.5 years, and the family was told what families are always told, that these things happen and nobody is at fault. Ensminger had given the Corps 24.5 years. He believed them, but the base where his wife had carried Janey had been putting industrial solvents into its own drinking water for decades, and the Corps' own laboratory had written that down by hand on a printed form with an exclamation mark at the end. 4 years before the wells were shut off, and 16 years before anybody told the families anything. 41 years later, that piece of paper sits inside a federal lawsuit with roughly 408,000 claimants behind it, and a court that has told both sides they have until the 30th of October to finish this. Camp Lejeune, North Carolina. It begins with a well. Camp Lejeune is a Marine Corps base on the flat coastal plain of North Carolina, all pine and sand and brackish water, and for most of the 20th century, it was also a town. Families were assigned quarters. Wives hung sheets on lines strung between brick duplexes. Children left tricycles on the concrete walks. Men who had been shouted at for 13 weeks in boot camp came back a decade later as sergeants with mortgages and station wagons, and their sons went to the base school, and their daughters were born at the base hospital, and the whole arrangement rested on a simple understanding. The Corps looks after its own. Jerry Ensminger was one of those men. He enlisted, he stayed, and by the mid-70s he was a drill instructor, which is the most concentrated form of the institution there is. The man who stands in front of 18-year-olds and embodies everything the Marine Corps says about itself. He and his wife lived in base family housing at a place called Tarawa Terrace from 1973 to 1975. She spent the first 3 months of her pregnancy with Janey there. Then he was sent to drill instructor school at Parris Island, and on the 20th of December 1975, they left. What they drank while they lived there came out of the tap like anybody's. That is the whole horror of this story, and it is worth being exact about it because there is no villain in a kitchen. There is a tap and a glass and a woman filling it because her husband is coming off duty and she is thirsty and the day is 90 degrees and the air will not move. Coffee, ice trays, baths for the children, a hose on the lawn. Nobody in the history of that base ever looked at a glass of water and thought about it for a second. Underneath the housing at Tarawa Terrace, the groundwater had been picking up tetrachloroethylene, a dry cleaning solvent called PCE, from an off-base business named ABC 1-Hour Cleaners. It had leaked into the aquifer that fed the wells. 4 miles away at the working heart of the base, the Hadnot Point system was drawing up a different solvent, trichloroethylene, TCE, an industrial degreaser, along with benzene, and the chemicals that TCE breaks down into as it sits in the ground. The Marines were not doing anything unusual. Half of American industry in 1965 kept solvent in open drums behind the shop. The unusual part is what was underneath. The measured numbers, when they finally existed, were not close calls. In the drinking water at Tarawa Terrace, the maximum recorded level of PCE was 215 micrograms per liter. The federal limit is 5. In the drinking water at Hadnot Point, the maximum recorded TCE was 1,400, 280 times the limit. But nobody at the base was measuring for any of that, because in the 1950s and 1960s and most of the 1970s, nobody in the United States was. The limits themselves did not exist yet. Janey Ensminger was born in 1976 after the family had left. She was, in her father's words under oath, born seemingly normal. She was diagnosed with acute lymphocytic leukemia at the age of 6. She was ill for nearly 2.5 years. She died at 3:35 in the afternoon on Tuesday, the 24th of September, 1985, and she was 9 years old. And this film is not going to describe any part of that beyond what her father chose to say about it in a hearing room 22 years later, on the record in public, because he decided the country ought to hear it. What happened after a child died on a Marine Corps base in 1985 was nothing. There was no letter. There was no notification. There was no suggestion from anyone that the water in the quarters had anything to do with anything, and there is no evidence that anyone at Camp Lejeune in 1985 connected the two. The family buried her, and the father went back to work, and the Marine Corps went on, and for 12 years, the two facts sat in different filing cabinets in different states and never touched. In August 1997, Jerry Ensminger learned that the water at Camp Lejeune had been contaminated. He has been precise about the date ever since, because the date is the accusation. It was 14 years after Janey was diagnosed. It was almost 12 years after she died. What he found out was that a federal health agency, the Agency for Toxic Substances and Disease Registry, ATSDR, was proposing a study of childhood leukemia and non-Hodgkin's lymphoma among children exposed in the womb while their parents lived at Camp Lejeune between 1968 and 1985. Read that back slowly. A federal agency had a hypothesis specific enough to write down. It named the base. It named the years. It named the exposure in the womb. And the man whose daughter had been conceived in that housing and had died of exactly that disease at exactly that age found out about it by accident more than a decade later as a civilian. This is the point where most people go quiet and where this story turns, because Ensminger did the opposite. He was 51 years old, he was retired, he had no legal training and no scientific training, and what he had instead was 24 and a half years of learning how a military bureaucracy actually moves paper. He knew there would be paper. There is always paper. Somebody sampled that water. Somebody wrote a number on a form. Somebody signed the form and somebody filed it. And government files do not evaporate, they get boxed. So he began asking for them. Requests under the Freedom of Information Act. Letters to the base. Letters to Headquarters Marine Corps. Letters to the Navy. Requests that came back partial. Requests that came back late. Requests that came back with the useful part removed. Requests that came back with a reference to another document that he then had to request in turn, which is how the thing propagates. He put what came back in a ring binder. Then he needed a second binder. Then he started using index tabs. That binder is the object at the center of this film. It grew for the next quarter of a century. It is the reason anything is known about Camp Lejeune at all, and it is worth being clear about who built it. Not a journalist, not a regulator, not a member of Congress. A retired drill instructor at a kitchen table in North Carolina, working through the evening after dinner, teaching himself to read a laboratory form. Along the way, he found the others. There were always others. That is the arithmetic of a base that housed a moving population for 34 years. There were mothers who had miscarried at Tarawa Terrace and never wondered why. There were men from the barracks at Hadnot Point with kidney cancer at 50. There were families who had left in 1974 and scattered to Ohio and Texas and Florida and had no idea they had anything in common at all, because the one thing the Marine Corps had never done was tell them. That failure is not an inference. It is Ensminger's own sworn testimony to a committee of the House of Representatives on the 12th of June 2007. Ironically, most of these people still do not have any idea that they were exposed to these contaminants at Camp Lejeune. They have not been notified, and the United States Marine Corps has to date refused to institute any type of legitimate notification plan or policy. He also told them what he was, which is the most useful sentence anybody has ever produced about this case. Through these people's misconduct and their deceit, they haven't filled me with a lot of pent-up anger. What they have filled me with is a terrible resolve to expose their misconduct, their arrogance, and their incompetence. And I want to expose the truth. By then, he had the paper. Here is what the paper turned out to say, and it is not what anyone expected, because it is not a memo and it is not a decision. It is a technician's note in a margin. In October 1980, a team from the United States Army Environmental Hygiene Agency, based at Fort McPherson in Georgia, began running routine tests on water systems at Camp Lejeune. They were not looking for solvents. They were looking for trihalomethanes, which are the byproducts you get when you chlorinate water, and which every municipal system in America has to check. It was housekeeping. The samples would not behave. A doctor named Michael Groh, who later testified about it, put the mechanism as plainly as anyone has. The routine tests showed the presence of major contamination with other organic chemicals, which required further action. Levels of these contaminants were so high so as to preclude THM testing. The water was so full of something else that the test for the ordinary thing could not be completed. So the analyst wrote it on the form. 30th of October 1980, on a Hadnot Point sample form, water is highly contaminated with low molecular weight halogenated hydrocarbons. 2 months later, on the 29th of December, another note on another form, heavy organic interference at CHCl2Br. You need to analyze for chlorinated organics by GC-MES. That is a laboratory technician telling the customer, in the customer's own paperwork, that they are testing for the wrong thing and need to go and test for the right thing. And then on samples dated the 9th of March 1981 at Hadnot Point, the Army's own laboratory wrote the sentence that this entire case has turned on for 4 decades. It is 9 words long. It ends with an exclamation mark, which is not a thing analytical chemists put in remarks boxes. Water highly contaminated with other chlorinated hydrocarbons. Solvents. That form has a number. It is CLW0443, and it sat in a government file for 16 years until a retired drill instructor asked for it. Nothing happened. That is the finding, and it needs no adjective. The wells kept running. The families kept drinking. In May 1982, a co-owner of a private contract laboratory called Granger, a chemist named Mike Hargett, telephoned the base's own supervising chemist to say his lab had found high levels of volatile organic compounds in both the Hadnot Point and the Tarawa Terrace systems. In August, his colleague Bruce Babson put it in a letter to the commanding general. These compounds appeared to be at high levels and hence more important from a health standpoint than the total trihalomethane content. More important from a health standpoint. That is 1982. The contaminated wells at Hadnot Point came out of service between November 1984 and February 1985. The most contaminated of them were shut down that February, 7 months before Jerry Ensminger died. The Tarawa Terrace treatment plant, the one that had served the family housing, was not closed until 1987. So the film's central arithmetic is this, and every number in it is from a government source. The Army's own laboratory wrote highly contaminated in October 1980. It wrote solvents with an exclamation mark in March 1981. A private laboratory said it again in 1982. The wells came offline at the end of 1984 and the start of 1985. The last plant closed in 1987, and the families were not told. It is important to say precisely what that does and does not prove, because this is where documentaries about this subject usually go wrong. It does not prove that anybody at Camp Lejeune understood in 1981 what those chemicals do to a human body. The federal drinking water limits for TCE and PCE did not exist until 1989 and 1992. It does not prove a conspiracy. A federal criminal investigation looked for one for 18 months, found no violation of federal law, and was declined for prosecution in 2007. And the Marine Corps' own review panel concluded that the Corps had acted responsibly. What it proves is narrower and, in its way, worse. It proves that the institution measured its own water, wrote down that the water was heavily contaminated, and then took between 3 and 6 years to turn off the taps, and then did not go and find the people who had been drinking it. The exposure window Congress eventually wrote into law runs from the 1st of August 1953 to the 31st of December 1987. ATSDR's own modeling is narrower and splits by system. At Hadnot Point, at least one compound exceeded the modern federal limit from August 1953 through January 1985. At Tarawa Terrace, families in that housing were drinking PCE above the limit from November 1957 to February 1987. How many people is that? Nobody knows, and this film is not going to pretend otherwise. There is no official total. No federal health agency has ever published one. The number you may have seen, around 1 million, comes from a congressional hearing in 2010. What exists is what Ensminger said under oath, and it is enough. Hundreds of thousands of Marines, sailors, their families, and the loyal civilian employees who were unknowingly exposed. On his 18th wedding anniversary in 2007, a 40-year-old insurance adjuster in Tallahassee, Florida, sat down with his wife to be given a diagnosis. He described it under oath to a committee of Congress 3 years later, and he began with the sentence itself because it is the only way to convey what it is like. "You have male breast cancer," were the words which greeted me and my wife on our 18th wedding anniversary. His name is Mike Partain. He is the son and grandson of Marine Corps officers. His father, a captain, was stationed at Camp Lejeune after graduating from the Naval Academy, and Partain was conceived, carried, and born there at the base Naval Hospital in 1968 while his parents lived at Tarawa Terrace. He had no family history of the disease. He tested negative for the hereditary breast cancer markers. He did not drink and he did not smoke. Male breast cancer accounts for less than 1% of all breast cancer cases in the United States, and he was 39. He found out about the water from a television report while he was being treated. And then he did what Ensminger had done. From the other end, he started looking for men like himself. He found them. By September 2010, when he testified, he could tell Congress that he was one of 64 men who share the unique commonality of male breast cancer and exposure to the contaminated water aboard Camp Lejeune. He had located 63 others himself, one at a time, on the telephone and by email, and through veterans' halls. By this year, the count he keeps stands above 125. And here, this film has to be more careful than it would like to be. That list is a registry one man assembled. It has no denominator and no control group. When federal epidemiologists actually tested the question, 71 cases against 373 controls, published in 2015, the odds ratio for ever having been stationed at Camp Lejeune came out at 1.14, with a confidence interval that runs straight through 1. In plain English, on male breast cancer specifically, the results point both ways and nothing is established. But that is not what the list was for. The list was an alarm, and alarms are supposed to be crude. 64 men with a 1% cancer, all connected to one water system, is the kind of thing that makes a government agency go and look properly. And that eventually is what happened. When he testified in 2010, Partain read the March 1981 remark aloud to the committee, the chlorinated hydrocarbons, the capital letters, the exclamation mark, and then finished it with 5 words of his own. No further action was taken. What the agency found when it looked at itself first was not flattering. In 1997, the same year Ensminger started asking questions, ATSDR had published a public health assessment for Camp Lejeune. On the 28th of April 2009, at a meeting with the community panel in Atlanta, the agency withdrew it. According to Partain's sworn testimony, it was the first time in the agency's history a public health assessment had been withdrawn. The reason ATSDR gave that May is in its own words, and it is a confession in bureaucratic clothing. Benzene had been present in a drinking water supply well at Hadnot Point. That well was shut down sometime before 1985. The information should have been included in the PHA but was not, and the assessment should have mentioned the contamination and stated that the extent of exposure to benzene from that well was unknown. An agency withdrew its own assessment. It had published a judgment about a base full of people, and 12 years later, it took the judgment back because it had left out a chemical. Meanwhile, the studies that would take the science somewhere firmer were finally being run. Mortality studies published in 2014 comparing more than 154,000 Marines and sailors from Camp Lejeune against a matched group of the same size from Camp Pendleton in California. And then, in October 2024, a cancer incidence study across the same 2 populations, following diagnoses from 1996 to 2017. The 2024 study is the closest thing to an answer that exists, and its conclusion is worth quoting exactly, because the temptation to inflate it is enormous. Increased risks of several cancers were observed among Marines, SHOSH, Navy personnel, and civilian workers exposed to contaminated drinking water at Camp Lejeune compared with Camp Pendleton. Observed. Compared with. The elevated risks it found sit in the myeloid cancers. All myeloid cancers, acute myeloid leukemia, myelodysplastic and myeloproliferative syndromes, and in cancers of the esophagus, larynx, soft tissue, and thyroid. Separately, ATSDR's 2017 review of the evidence went further about the chemicals themselves, finding sufficient evidence for causation for TCE in kidney cancer and non-Hodgkin's lymphoma, for PCE and bladder cancer, for benzene and leukemias, and for vinyl chloride and liver cancer. That is the honest state of it. The chemicals cause these diseases. Whether they caused any particular person's disease is a question no study has ever been able to answer, and it is the exact question the American legal system was about to be asked 408,000 times. For 30 years, there was no lawsuit, and the reason is one of the driest doctrines in American law. North Carolina has a statute of repose. Unlike a statute of limitations, which starts running when you discover you were injured, a statute of repose starts running from the defendant's last act and then simply expires, whether you know anything or not. A Supreme Court case in 2014 confirmed that federal environmental law does not override it. About 4,000 claims and 17 federal lawsuits had already been filed by Camp Lejeune families. In December 2016, they were dismissed. The court held that the 10-year clock had started running on the day the contaminated wells were taken out of use. And they had been taken out of use in the 1980s, a decade and more before almost anybody knew there had been anything to sue about. The claims were too late because the water had been turned off. Congress fixed that, and it is worth giving Congress the credit because it did the job properly. In 2012, the Jerry Ensminger Act, named for her, sponsored in the House by a North Carolina congressman, signed on the 6th of August, gave veterans and family members who had been at Camp Lejeune for 30 days or more between 1953 and 1987 access to VA health care for 15 specified conditions. 5 years later, the VA added 8 presumptive conditions for disability compensation. Then on the 10th of August 2022 came the Camp Lejeune Justice Act, passed as Section 804 of the PACT Act. It created a cause of action in a single federal court. Every claimant in the country had to file first with the Navy, wait 6 months for an answer, and then bring the case to one district in eastern North Carolina. 4 judges, 1 courthouse, for everyone. It waived the government's immunity, including the discretionary function defense that had beaten these claims before. And it took the statute of repose off the board entirely. Any applicable statute of repose or statute of limitations shall not apply to a claim under this section. Most remarkably, it lowered the burden of proof to a standard almost no plaintiff ever gets. A claimant must show that the relationship between the water and the harm is sufficient to conclude that a causal relationship is at least as likely as not. 50-50 is enough. Every wall was down. And then the country found out what happens when you open a courthouse door that has been shut for 30 years. Law firms spent nearly $112 million on television advertising for Camp Lejeune claimants in 2022 alone. More than double the next biggest mass tort in America, according to the firm that tracks it. Between late March and the end of September that year, about 94,000 Camp Lejeune commercials aired in every media market in the country. The people this film is about spent 25 years trying to make anyone listen. The advertising industry needed 6 months. The filing window was 2 years, and for almost everyone it closed on the 10th of August 2024. By the middle of June 2026, the Department of Justice told the court the number: 408,000 deduplicated administrative claims, 3,759 lawsuits on file in the Eastern District of North Carolina. Every one of those files rests, somewhere near the bottom of it, on a laboratory form that a retired drill instructor had to ask the government to hand over 16 years after somebody wrote on it by hand and put an exclamation mark at the end. Then came the reversals, and they came from inside the courthouse. The first was the jury. Section 804 contains the sentence, "Nothing in this subsection shall impair the right of any party to a trial by jury," and every claimant read it the obvious way. On the 6th of February 2024, all 4 judges of the district signed a 34-page order holding that the Act does not unequivocally, affirmatively, and unambiguously provide plaintiffs the right to a jury trial, and struck the jury demand. The sentence that looked like a guarantee was doing something else. Every Camp Lejeune case will be tried by a judge. The order contains a line that reads like an apology. Congress could have made this dispute easy to resolve. The second reversal is the evidence. Congress lowered the burden to at least as likely as not, and the government met it head-on with 31 separate motions about causation. Awards are also offset by whatever the claimant already gets from the VA, from Medicare, or from Medicaid. To move things along, the court picked 25 bellwether plaintiffs, 5 each for bladder cancer, kidney cancer, leukemia, Parkinson's disease, and non-Hodgkin's lymphoma, and required every one of them to waive their claims for every other illness to be selected. Not one of those cases has been tried. 4 years after the law passed, there is no trial date. What there is settlements. The government runs an elective option that pays on a grid, $150,000 to $450,000 for the worst exposed with the listed cancers, another $100,000 if the claimant died. By June 2026, the Navy had approved 3,094 offers and sent payment on 2,341. The Justice Department had paid 105 more. Total payments, $723,850,000. As of that filing, roughly 2,446 people had been paid, out of 408,000 who filed. Of the offers the Navy approved, 1,151 were claims for an injury that had already resulted in death. And a reporter in North Carolina found this summer that at one firm alone, close to 1 in 10 of its Camp Lejeune clients had died within 2 years of filing. The government's explanation is in the same filing. Of the claims with even the minimum documentation, more than 88% have insufficient evidence to support the claim, and less than 2% have sufficient documentary substantiation to meet the EO requirements. Read carefully, that is a statement about paperwork. And the paperwork it wants is medical and service records from the 1960s and 1970s, held by the institution being sued. And then at the bottom of that same June filing, 3 sentences that a father at a kitchen table in North Carolina has been working toward since 1997. The United States had reached agreement on settlement amounts for 3 of the 25 bellwether cases. Robert Fiolek, leukemia, $10,000. Edward Raymond, bladder cancer, $24,000. Jose Vidana, non-Hodgkin's lymphoma, $405. $405. Paid and the case dismissed. On the 30th of June 2026, the 4 judges of the Eastern District of North Carolina reappointed the plaintiff's leadership group and reappointed it only until the 30th of October. After that date, the order says, the court will evaluate whether a new leadership group is needed, as well as other action relating to either the PLG or the Department of Justice. In the meantime, the lawyers in the government must meet the settlement masters every single week, and a week can only be skipped if the settlement masters approve it in writing. The court wrote that it expects both sides to use their best efforts to achieve a global settlement by October 30th, 2026. That is where this stands as this film goes out. Not a verdict, not a finding, a deadline imposed by judges who appear to have run out of patience with everyone in front of them. The lawyers who speak for 408,000 people hold their authority only as far as that date. What happens on the 31st of October, the order does not say. No court has ever ruled on whether the United States is liable for any of it. No individual, no officer, no official, no civilian employee has ever been publicly disciplined or prosecuted over the contamination. Jerry Ensminger is still doing this. So is Mike Partain, who says the strategy on the other side has always been the same 3 words and a fourth: delay, deny, and wait till they die. The binder is still on the table. The base is still there, and the pines still come down to the water, and somewhere in a records facility, the form from the 9th of March, 1981 is still exactly what it always was. 9 words and an exclamation mark, written by a technician who was only trying to finish a routine test, and who did the one thing this entire story turned out to need. He wrote down what he found. Everything after that was other people deciding what to do about it. If you think a government that measures its own water owes the people drinking it the result, hit like, so the next one of these gets told before the deadline instead of after.